SJC-13029, CommCan Inc. v. Town of Mansfield.
Okay. Ms. Kawamoto?
Yes. Good morning, Your Honors, and may it please the Court. Noemi Kawamoto on behalf of the defendant appellant, the Town of Mansfield, in this action. The town has appealed the judgment issued by the land court because the judgment lacks both legal and factual support and should be reversed for a number of reasons. First and most importantly, the land court failed to apply Chapter 93G, Section 3 as written. The text of that section, relevant part, provides that zoning ordinances or bylaws shall not operate to prevent the conversion of a medical marijuana treatment center licensed or
Counsel, before we get to that argument, can you talk to me about the standing argument? Because I'm a little bit confused by that. I'd love to get to that issue, but is the town still contending that there's no standing here?
Yes, the town is. I believe that under Chapter 240, Section 14A, it is only the owner of a freehold estate that has standing under this section to bring an action, and CommCan, who is the licensee, is not the owner. However, in addition, under that statute, there is no cognizable claim here.
But Rosenfeld is the owner, and she's a party.
Correct, but you can't combine the two plaintiffs in order for them to have standing. Each plaintiff separately must have standing on its own.
Okay.
But in addition, under that statute, there is no cognizable claim here because all the land court did was look at the validity of a bylaw. The Whitensville case here is instructive in that case, the court found that there was no jurisdiction because in the lower court's discussion, all the judge had ruled was relating to there was no ruling relating to the determination of the validity or extent of any municipal zoning ordinance, bylaw, or a special permit. In that case, the lower court had declared that by virtue of a special permit that certain zoning bylaws did not apply to the plaintiff.
Counsel, can I stop you there? Because it
Yes.
sounds like you're going to the merits and not necessarily the issue of jurisdiction. That is whether the land court had the power to entertain the claim.
Correct.
All right, so you're arguing the merits. You're conceding that the land court had jurisdiction.
No, I do not concede that they had jurisdiction.
And so what is your argument that the land court does not have jurisdiction? It lacks the power to even address the claim.
The land court under Section 14.8 only has the power to address the validity of a zoning bylaw or ordinance. Here, the land court was interpreting a statute.
Excuse me, can you just slow down just a little bit? I'm
Yes,
having
I'm sorry.
trouble hearing you, and combined with the velocity of your speech, I'm having trouble.
Yes, I apologize. Under Section 14A, the land court only has the power to determine the validity of a zoning bylaw or ordinance. Here, what the land court was doing was looking at the application of a statute and interpreting a statute. The plaintiffs have attempted to cast this as an issue concerning the validity of a bylaw, limiting retail marijuana establishments to a particular zone in Mansfield by claiming the town could not enact a bylaw that prevents the conversion of a medical marijuana treatment center to a retail establishment. However, Section 3 does not prohibit the town from enacting such a bylaw. Chapter 93G, Section 3 simply prohibits a bylaw from operating to prevent the conversion of a medical marijuana treatment center to a retail establishment. In other words, if Chapter 94G, Section 3 applies to CommCan, then Mansfield's zoning bylaw regarding retail marijuana does not apply to CommCan and to CommCan only. It does not mean that the bylaw limiting retail marijuana establishments to a certain zoning area is invalid. In fact, that zoning bylaw would be valid as to all other persons, meaning that the land court simply did not have jurisdiction to just interpret the statute with no reference to the validity of the zoning bylaw.
I must say, I find that argument incredibly confusing because it seems to me that what the land court was asked to do, and it has power to do, is to determine the validity of the Mansfield ordinance or bylaw that precluded the conversion of the medical marijuana dispensary to a retail medical marijuana establishment.
Right.
And that was the question being asked for the land court to determine. Separate and apart, I understand the town's argument that, in fact, they're allowed to do what they did, but the determination of the power of the land court to do this seems to me beyond question.
Well, I disagree with that because I don't believe they were ruling on the validity of the bylaw itself. The bylaw, I believe, remains valid as to all the other persons. What the land court found was that the bylaw simply didn't apply to CommCan.
Okay.
Okay.
In any case, the land court failed to apply Chapter 93G as written. Under the statute, it requires three separate things. It requires that there be a treatment center that is licensed or engaged.
I'm going to ask you to go super, super slow, okay? And then also speak into the microphone because I really am having trouble hearing and understanding you.
Yes, so under the plain terms of the statute, several conditions must be met in order for the statute to apply. First, there must be a treatment center that is licensed or registered no later than July 1st, 2017, and that is engaged in the sale of marijuana. All of these things are required. The land court, however, ignored the words engage in the sale of marijuana and determined that because the plaintiffs are engaged in the activities authorized by their provisional
Counsel,
license.
let's get to the heart of that argument. The engaging in the cultivation, manufacture, or sale of marijuana. Is the town's position that the only way to comply with that language is that they actually have started construction?
Not only have started construction, but have actually engaged in the cultivation, manufacture, or sale.
Okay, now, this isn't as if, in this case, CommCan just sat on their hands. They've been embroiled in litigation over the issuance of the permit within the butter. It actually went to trial and it's on appeal. So they've done everything that they can, in which leads to, I know the question about the judicial notice aspects of this, but the crux of all of this is they wanted to build, they tried to build, they did everything that they could to build, but then as of right, and the butter filed an appeal, and that needs to be fully vindicated and decided. So what else were they to do? I know in your brief, you say kind of blithely, well, they could have just built at risk. They could have just gone ahead and who knows how it would have ended up. But is that going to be the test of whether or not we're saying that they did that they're engaged, that we tell them to just go out and do something that business-wise wouldn't be advisable?
Yes, I believe it is, because that's what the statute requires. The statute requires CommCan to be engaged in the manufacture, cultivation, or sale of marijuana. And I think if you look at the legislative history, it makes clear that being simply registered and simply engaging activities leading up to that cultivation, manufacture, or sale are not enough. Prior to July 28, 2017, the prior statute provided that zoning ordinances or bylaws could not prohibit placing a marijuana establishment in any area in which a medical marijuana treatment center was registered to engage in the same type of activity. The legislator later changed that to allow medical marijuana treatment centers that were actually engaged in the manufacture, cultivation, and sale of marijuana to convert as of right to a retail establishment.
Do you, counsel, see a difference between engaged in the cultivation, manufacture, or sale and cultivating, manufacturing, and selling? That is, it seems to me your position reads out engaged in and requires the cultivation, the manufacturing, and the selling.
Yes, that is correct.
So you're actually asking us to read out the phrase engaged in.
Yes, because engaged in refers specifically to being engaged in the activities of cultivating, manufacturing, or selling.
And normally in statutory construction, we give each word a meaning, and you're suggesting that in this situation, engaged in has no meaning. In fact, we should strike it, and it should instead be that the medical marijuana establishment must actually be manufacturing, selling, and cultivating.
I don't necessarily think you need to strike the words, but I think engaged in has to be read in conjunction with those words, which means that yes, they would need to be cultivating, manufacturing, and selling.
even though that's what the statute doesn't say.
No, I believe that it does. I believe engaged in the cultivation, manufacture, or sale does, if you read those words together, does require them to be cultivating, manufacturing, and selling.
So
Or
you
selling.
are saying there's a difference between engaging in selling marijuana and engaging in activity to prepare to sell marijuana. Is that what?
Yes.
Is that what?
Yes, Your Honor, that is the distinction that I am trying to make.
And it doesn't matter whose fault it is that, had everything gone the way they had hoped it would, they would be selling marijuana.
Correct. I do not think that matters because I think as a matter of policy, what the legislator was looking to do was to allow an establishment that already had experience in selling marijuana and had relationships with the community, had understood the community impact of this marijuana establishment to expand its operations, which is not the case here.
Didn't the city say, hey, go for it? We say, okay. Didn't the city already, they gave all the permits and said, go, right? The city was all
Yes.
right with it.
Yes, that's correct.
So why would the city have a problem now with allowing it to switch over to retail sales?
Because I think that there's a difference between a medical marijuana establishment and retail sales. It attracts different clienteles. It could have different impacts on the community. And there is no medical marijuana facility to speak of where there are employees who have had experience with the sale, where there's data to show what kind of community impact that facility has on the community.
But
that
you guys were
experience.
willing to allow it. You guys were, you said, go forth and build the medical dispensary. That's
Correct.
that's what you guys said. And,
Yes,
and
and
now you're saying, no, don't go. And no, even though there is a section of the statute that applies to this company, we don't want you to use it because we're gonna look at engaging in very narrowly.
Well, that's not true. We're not saying that they can't build and construct their medical marijuana establishment. That permit, I believe, still remains valid and they can still engage in those activities. However, what our position is that they are not entitled as of right to convert to a retail establishment.
You've got a little more time if you want to say anything
Counsel,
else.
may I ask a further question? So if it's going to come down to what definition we ought to give to engaged in the sale, cultivation, or manufacture, let's just say I agree with you that or let's just say that there's uncertain. We have regulations from the CCC, don't we? And the CCC adopts regulations interpreting 94G. And one of those regulations talks to receiving a provisional certificate of registration. And so isn't that something that CommCan had? And so shouldn't we let that control as to whether or not they've met the test of engaging in all of those other things?
I don't believe so because the CCC only has as much power as the legislature gives it. It doesn't have the power to issue regulations or guidelines that conflict with the statute. To the extent that it's saying that having a provisional license is engaged in, it conflicts with the statute because if you have only a provisional license, you're necessarily not engaged in the cultivation, manufacture, or sale of marijuana. And so
we shouldn't give any deference to the regulations of the CCC interpreting the statutory provisions?
not in this specific instance where their interpretation conflicts with the statute.
Any other questions? Okay, thank you so much.
Thank you, Your Honors.
Mr. Taylor.
Thank you, Your Honors.
Ellerman, I'm sorry.
And may it please the court, thank you for accommodating us here today. It's been close to a year since I've seen the inside of a courtroom, so
Welcome.
this is exciting. So let me just address something on the standing issue. I think that Your Honors laid it out carefully in the prior argument by my sister. The issue here isn't us attacking this zoning bylaw. They're free to adopt a zoning bylaw that operates to restrict marijuana to a certain district. The issue here is as applied to our particular use, which is consistent with the cases. Ms. Rosenfeld is clearly an owner of the property. She doesn't have to exhaust administrative remedies, and she was clearly properly before the land court, which cited all those reasons, cited all of the cases, and I'm not aware of a case in this situation that would stand for a contrary proposition on that. The bylaw is in conflict, as we've suggested, or in tension with, at the very least, the provisions of 94G Section 3, which says that if you are licensed as of a certain date, and the regulations do state that a provisional license is sufficient to do a conversion. If you are licensed by a certain date, and the cutoff was July 1st, 2017, then you have the power to convert, or no bylaw may prevent you from converting. Now, we concede that there are other hoops we'd have to jump through at the local level. We'd have to redo our host community agreement, and we'd have to amend our special permit. But the bylaw itself can't operate to prevent that conversion.
Counselor, can I ask you to go back to the standing question?
Sure.
So Rosenfeld has standing. Does CommCan?
CommCan's not the owner, although it's controlled wholly by Ms. Rosenfeld. But that's not the issue here. The issue here is whether or not an owner of a property, and Ms. Rosenfeld, by the way, is the recipient of the special permit. The fact that she's going to be using a corporate entity for the licensure and operation purposes is irrelevant for the standing issue. As an owner, she is entitled to a declaration.
Right, which is why I started off my question with the premise that she has standing. The question is, does CommCan?
That issue was addressed at the land court. So we pled it together so that we could have all the facts out there, because Ms. Rosenfeld controls both entities. Technically, CommCan does not have standing because they're not the owner of the freehold estate. The judge felt, I think at that point, look, we're here on summary judgment. It doesn't make a lot of sense to have a partial dismissal. Let's go forward. He only addresses the standing of Ms. Rosenfeld. We did not offer a challenge in any way, shape, or form. There's no separate appellate argument with respect to CommCan. We submit and agree for the record that it is Ms. Rosenfeld that possesses the standing here.
So that doesn't make a difference then?
I don't think it makes a difference in the outcome, Your Honor, because again, she has the authority to do it. Whether or not she's the corporate entity that will actually be opening the doors of the dispensary is irrelevant for the purposes of standing before the land court. So the crux of the question before the land court, as we wound through and got
before we leave the standing, are there good cases for us to look at on this sort of mixed issue where one person has standing and they're also the corporate? I mean, they're essentially controlling the other. Is there any good land court decisions or anything else we could just look to for guidance on that point?
We never mined down that deep into that, Your Honor. We weren't asked to brief that, and it wasn't an issue here pled before you as a separate argument. Again, we submit for the record that Ms. Rosenfeld
Well, you know,
is the
counsel, I
operable
mean, that is entirely the first part of the brief by the town of Mansfield. They're saying CommCan has no standing. I don't see how you can say that that was not an issue briefed below or here.
Well, again, we're not arguing, if the issue is the relationship part affecting Ms. Rosenfeld's standing, if that's the question, then we would submit that relationship has no bearing. My point is, it would have no bearing on Ms. Rosenfeld's standing, the fact that there's a second entity. Again, we are not arguing here today that CommCan has a right under 240-14A. It is specific as to the owner of a freehold estate. If the land court had kicked CommCan out, we would have been comfortable with that and we would have proceeded accordingly. I think at that point, the land court was just pleased to get to the main part of this, which is is this entity engaged?
Well, if we get to that main point, well, you have it sold, dispensed, manufactured, any marijuana on the property. And so I understand that there might be some reasons why that ability was frustrated, but have you met the plain statutory language of 3A1?
We believe we have squarely, Your Honor, because as the judge went through it, look, if the legislature or the Cannabis Control Commission, which helped write some of this legislation, had chosen to say, until you open your doors, you don't have any rights accorded under the statute, they could have done that. They could have chosen their words carefully. Here they use the term, you have to be licensed and you have to be engaged in one of the classes of marijuana business. Here, this is a dispensary, so it would ultimately be sale. The judge was careful. Judge Speicher was very careful. He looked first to the common definition of the term engaged and talked about to essentially involved in an activity, occupied, or busy. Then he went to the facts of what it takes to become a marijuana entity, all the hoops that you have to jump through. You need a host community agreement. You've got to get licensure from the state. You have to spend $50,000 a year, as one of the amicus brief notes. You have to do that going forward. You need a special permit from the Zoning Board of Appeals. Then you've got to build the thing. That's a lot of activity to pack in, even if this hadn't been appealed by an abutter.
I'm sorry, Counsel, the statute doesn't say that. The statute says engaged in these categories, as you point out. And when I look at it, the question becomes engaged in what? And the what, the engaged in modifies, and what's pertinent here are sales, correct? So you have to be actively involved in sales.
So, and I think there's two ways to help answer that question. To the extent, first of all, to the extent there's an ambiguity in what were they talking about engaged, because there's obviously some difference of opinion here, then why don't we go to the Cannabis Control Commission's own guidelines?
Because what we have here, are, like I think Justice Scalia has said in the past, that, you know, just pick a rule of statutory construction that you want to come down the road. You get a better one coming around. So as Justice Wendland pointed out earlier, one interpretation takes out the word engaged in. They could just say someone who sells, cultivates. We don't have that. But then we have engaged in, and that engaged in is modified by sales. So it puts us kind of in that conundrum of ambiguity.
Well, so again, I think there are two ways to answer that, Justice Gaziano, and that is the first that the court relied on, because they felt it was unambiguous and didn't reach our argument below about the guidelines from the Cannabis Control Commission. They answered it initially. The initial answer was to draw reference again from the Merriam-Webster dictionary, which talks about pursuit of an activity, so pursuit of sale. And then they analogized, and it's not too far from this actual statutory scheme, the zoning cases, which are highly developed in this area regarding the exercise of a variance, particularly the Green case, the Green Southborough case, where there's a very short time period to exercise a zoning variance. And people struggle with that. Developers struggle with that all the time. But what the court has said and what they have fashioned through the case law is that you don't actually have to build the house that you got the variance for, but you do have to take the steps to actively pursue that. And that's why the judge draw reference from the Green case, and there's other cases like that too.
I assume there's no statutory history that's going to help us out, like your legislative history on this issue.
No, this is the first case, and likely the last case, because there's only a limited number of dispensaries that fall into this narrow band. So it may be of utility once, or maybe academics will be interested in the outcome, or maybe it'll have some clues for statutory construction, but it's likely to never arise again, and it certainly hasn't arisen previously. We do have, though, in terms of who's thinking about how this may be applied, the Cannabis Control Commission, which again has a series of regulations, and those have the force of law, And I'm not aware of a direct challenge by anyone to the legitimacy of those regulations. Certainly, the town of Mansfield hasn't attacked the validity of those regulations. Those regulations speak to how you might convert. What are the steps? What do you need to have? And they say you have to have at least a provisional. Well, we've got the provisional. The provisional exists. So we have that. Then, in addition to the regulations, the Cannabis Control Commission, which oversees the entire marijuana program, as we know from the prior argument and in the argument here, they have issued guidance to municipalities. I represent a lot of municipalities. We take that guidance very seriously because these statutes came at us so fast and so quickly, and they're so comprehensive, and the regulations are so thick that we rely on the guidance from the Cannabis Control Commission frequently. Here, they said specifically in that guidance document that all you need is your provisional. If you got the provisional, you're engaged. That's the guidance they gave. It was specific to that. And while we only reach that if this court finds that there's an ambiguity, there is value in looking at the Cannabis Control Commission guidance, especially where, as here, pursuant to statute, they have a substantial governing role in the entire process. So whether it's unambiguous, which we would contend, or ambiguous, there's ample support in the cases and in the logic of the land court judge for reaching the conclusion they did. And with that, unless there's further questions, I'll
Can I ask you
just-
2 questions?
Sure.
One, can you address the status of the appeal?
Sure. The
And
appeal.
2, can you tell me whether or not it was there was a contested fact on the construction finance point that the judge took judicial notice of?
There was not, so 2 things. The status of the appeal is we're waiting for a date for, it's fully briefed. We're waiting for a date for oral argument at the appeals court. It is not on the merits. It's only on this unique question of nonprofit versus for-profit for medical dispensaries. So it's a very narrow question, but it is still preventing us from going forward. The fact regarding, I'm sorry, specifically the question?
I thought it was a judicial notice point, basically.
Yeah, so the judicial notice point, which I don't think is essential for deciding this case, the land court wanted to know what was going on there. So they asked, following the oral argument on
Right,
summary
and somebody
judgment.
submitted an affidavit, and I thought the land court said that was undisputed.
Well, the land court took judicial notice of the fact. The
But
land
in
court,
addition to judicial notice, said it was undisputed.
well, I'm not aware of a dispute of that fact.
Okay.
I mean, Ms. Rosenfeld has relationships with lenders, but she can't go forward and actually
Counsel,
get.
just to that point, were the parties given an opportunity to know that Judge Spicer was going to take judicial notice of it? Were they given an opportunity to essentially contest? So it's undisputed, but is it undisputed because no one knew he was going to do it?
Well, he didn't give any highlight or premonition that he was going to take judicial notice of the fact.
Is he supposed to?
No, not at all. At the time, I felt that the reason why he asked for information regarding the companion case was to have a full picture of what other delays, in addition to all of the other hoops that Ms. Rosenfeld and CommCan have to jump through, are there additional delays? And so he just wanted to round out his understanding of the facts. That he took judicial notice was not something he forecasted to us at all. He didn't ask for further briefing. He just wanted to know the status of that case. I had mentioned that we had sought a bond. He wanted the information supporting that bond. There was never an issue that he presented that he opened up for further debate on that.
Any other questions? Okay, thank you so much, Counsel.
Thank you so
Thank you.
much.
Thank you, Counsel.